First of all, please join me in thanking Jerry Elmer and CLF for all that they've done. Without a doubt, and I'm speaking only for myself here, but without a doubt, you have not only inspired us, excited us. By the way, you're very intelligent. Did you know that? And you know what you're talking about. It's good to have you on our side. I always thought if Jerry was on the other side, we would have lost long ago. But you're on this side. I've got two questions for you. One dates back to August 1st, 2015, when the governor of the state of Rhode Island had that remarkable press conference with Invenergy and said, we will do everything we can to make sure you're successful here. That question is, has any of that political support waned over the past 4 years? And where is it today? And the second question is more personal. So what are you going to do next? Thank you.
So before I wrote down your two questions, and I will answer them, but let me say a word about your preamble about the thanks. Because we in CLF thank the people of Burrillville, because if it weren't for your efforts, we would not be where we are today. It was your efforts that got the Pasco Utility District to back away from that non-binding letter of intent with Invenergy to provide water. That led to a suspension of the docket while Invenergy got a new water supply. And it gave us time to mount a case. It gave us time to see the energy markets turn around, so that it was clear that there was no need for Invenergy. It was your efforts that got the Harrisville Fire District and Woonsocket to turn down Invenergy, which made them look terrible on the water, to try to get a supplementary water source, which allowed us to portray Invenergy before the EFSB as being not ready for prime time, which was an accurate portrayal, but you handed us that on a silver platter. It was you who got 31 or 3 cities and towns in Rhode Island to pass city council, town council resolutions against the plant, all of which has helped to turn the tide. So yes, we are very grateful for your appreciation of our efforts, but we are also very, very, very appreciative of your efforts, because we would not be here without you. I promise to address. So political support for from the governor and others, and yes, I will say 2 things. I think that in recent months and years, the governor has noticeably stepped back from her full-throated endorsement of Invenergy. Instead of saying, we will do everything possible to make it happen, she now says, oh, let the process work, let the EFSB decide. I think that we, CLF, and you, Burrillville folks, have put a lot of pressure on her to do more and to come out and say, I oppose the plant, it's wrong. We have been unsuccessful. She has not done that. I will say that I do not believe that the governor's publicly stated reason for not coming out clearly against the plan, what she says is, oh, well, the issue is before the EFSB, it would be wrong for me to comment. That's not a sound reason, because it didn't stop her when she wanted to say, I like the plan, I support the plan, we'll do everything to... if she was going to be quiet about this during the pendency of the proceedings, she shouldn't have held a press conference with Invenergy President Michael Polsky. So I don't think that her reasoning is sound. I think she has walked back or tried to walk back her full-throated support, and I think she's in an awkward position because she has national ambitions. She remembers the ubiquitous TV ads that were taken out against John Kerry when he ran for president saying, I voted for the bill before I voted against it. She doesn't want to be branded as a flip-flopper. Having supported the plan, she doesn't want to see attack ads showing her as a flip-flopper. I would like to have seen her do more. I have encouraged her, as have you. We have not been successful. What'll I do next? There's a lot out there. I mean, you know, one of the debates that we have had inside CLF is, do we attack the issue of climate change and the problem of carbon emissions one plant at a time, or do we pass laws like the Global Warming Solutions Act that caps and reduces carbon emissions and thereby takes away the occasion of having to litigate these cases one plant at a time? So having stopped one fracked gas and diesel fuel power plant is a very, very small part of what needs to be done. And if you're worried, you know, if you're worried that idle hands are the devil's playground, and that I will get into mischief of one kind or another, don't worry. Amy and CLF will keep me busy and off the streets and out of trouble. Yes?
Okay, I have two questions. The first of which is, do you have any idea if Invenergy has ever been turned down before, permit-wise, anywhere for their projects?
No, I do not know.
Okay. And the second one goes back to what you were just talking about, because this is a thing that's been driving me nuts the whole time. I don't understand why it wasn't a conflict of interest or an ethical issue for the governor to come out and support before the proposal got before the EFSB. It seems to me as if that's the permitting process, if that's the process, and she set it up for failure by putting herself out there and saying, we're going to do everything we can. I don't get how that's okay.
So we need to look at this as, I think we need to tease apart the technical legal aspects of it from the broader ethical or public policy aspects of it. As a purely technical legal matter, what is not allowed is for anybody, the governor, a state senator, you or me, to have a private conversation with a member of the EFSB about a matter that they are considering or are going to consider. So if I see a member of the EFSB, A or B or C, at a cocktail party, or if the governor sees one of the members of the EFSB at a cocktail party, they are allowed to discuss the Red Sox, the Patriots, anything in the world, but not the matter that is before the EFSB. So from a purely legal standpoint, the governor's press conference was not a problem or an issue. The ethical question is a little bit harder. Do a thought experiment. Imagine the Burrillville senator or the Burrillville town manager or the a member of the Burrillville town council holding a press conference and saying, this plant is a bad idea, it's not needed, and would cause unacceptable environmental harm. Anything wrong with that?
I think that would depend on the, oh, no, I'm
I
gonna say
don't-
no.
How about if I hold a press conference and say CLF is opposed to this power plant? We don't do this in the EFSB, we do it downtown at Burnside Park off Kennedy Plaza, and CLF stands up and says, this plant is a bad idea, it's not needed, and would cause unacceptable environmental harm. I don't think there's anything wrong with that. I think the governor's position was wrong, but I'm not sure that it was unethical. It was unwise, it was wrong. It may get her wrong in the sense of she took the wrong position on the case, but I'm not sure that it was wrong as an ethical or improper thing to have said, because if she had said, Michael Polsky is unwelcome in Rhode Island, we don't need more carbon-emitting power plants, we would have all applauded her. I think for a public official to take a public position on a matter of public concern and importance, even if the matter is in litigation, is not necessarily improper. Yes?
I was at the demonstration at the State House last night, and I have not come out to be active about this, even though I think we all need to. From the people and the tone of that, I got a very different impression from what I'm getting here, that it is indeed very threatening, that it involves a lot of political need to say no to certain people, and that it is a much more still alive project than what you were saying.
So, I'm not sure I understand what you're referring to, it.
The Invenergy project.
This is a clarification question. Are you suggesting that the impression you had yesterday was that I may be mistaken and overly optimistic and that the plant may yet be approved?
I think I am suggesting that many, many people at the State House thought that, and thought that the EFSB would in fact approve it. Now, I don't know who had what information, but that seemed to be the going assumption of that group of people.
Right, and I will say, again, I may be mistaken. I believe I'm right. On the other hand, I was careful to say, I believe that this outcome is likely. It is not a guarantee, it is not certain. I believe that my opinion is well-grounded in some knowledge of the case and experience, but mine is not the only view out there. I hope I'm right, but it is possible that I am mistaken, and I know that you also hope that I'm right. Believe me.
Yeah, thanks so much for that question. I think part of it is also the environment that you're in, and Jerry is an optimist, and the threat is real, but when you're in a rally at the State House and you're trying to fire people up, you sort of tend to use different language, and Jerry's much more methodical and analytical. But there is a chance that the EFSB could in fact grant a permit. So could you walk us through what would happen if that unfortunate event occurred?
So, yes, we'll come back to you. So I said yes, there would be an appeal. It is a certainty that CLF will join that appeal. So the case will not be over. We will be there to fight it in the Supreme Court. I do not represent nor speak for the town of Burrillville, but I believe that it is highly probable that the town of Burrillville would continue in on the appeal. Whichever, regardless of what the EFSB decides. Here's what you need to know about appeals from the Energy Facility Siting Board to the Rhode Island Supreme Court. The standard of review that the court uses in looking at a decision of the EFSB is very, very, very deferential to the EFSB. The Supreme Court is very, very, very reluctant to reverse a ruling of the Energy Facility Siting Board. I don't think it's ever happened. So if the permit is denied and Invenergy appeals, you can sleep well at night. If the permit is granted and we are appealing, all I can tell you is we will do the best we can. The first thing that Invenergy will do when we get to the Supreme Court is to challenge CLF's standing to be in the case. Standing is a legal doctrine that was created in the 1980s in order to keep environmental groups out of court. That's just the way it is. The way to explain standing to you is this. Let's say Amy and I have a car accident at the corner of Main Street and First Street. And Amy says that I jumped a red light, and I say that Amy wasn't wearing her glasses, and she hurt her back and she damaged my fender. Maybe I can sue Amy, and maybe Amy can sue me, but Heather in the back of the room cannot sue either of us. She wasn't involved. This doesn't concern her. This is not about her. She doesn't have standing. She's not a proper person in the case. It doesn't concern her. It doesn't affect her. So the first thing Invenergy will do when we get to the Supreme Court is to challenge our standing. That's the first thing they did in Superior Court when we sued them about the water contract with Johnston. There are cases that cut both ways on the issue of standing. When I represented Conservation Law Foundation in a very, very, very similar case that went to the Rhode Island Supreme Court over Champlin's Marina on Block Island, the other side challenged our standing, we stayed in. When Invenergy challenged our standing in the Superior Court case, we stayed in. On the other hand, in the Block Island Wind Farm case, CLF was the same organization represented by the same lawyer, and we got kicked out based on standing. So I can't tell you whether or not we will stay in the Supreme Court case until the end, although I can tell you that our standing will be challenged. Invenergy has done that before. They'll do it again. And I think the Supreme Court case will end, as I said, at the end of September. But yeah, so what'll happen if the permit is granted, as the people yesterday thought that it may be, is we will appeal. Burrillville cannot be challenged on standing because Burrillville is the home community, the site of the plant, so Burrillville will stay in, and the case will go to the Supreme Court. But whichever side is appealing in the Supreme Court, the standard of review is deferential. And I promise to come back to this.
My question is, do you have confidence in the integrity of the members of the EFSB since they are Gina's appointees?
Yes.
You have confidence they're able to operate independently of
Yes.
any political?
Meg Curran was the U.S. attorney who sent Buddy Cianci to federal prison for 5 years for turning City Hall into a corrupt racketeering enterprise. Meg Curran doesn't like improper things. Janet Coy came to DEM from the Nature Conservancy, where CLF's witness came from. In fact, CLF's witness on biodiversity issues at the EFSB, Scott Cummings, was hired by Janet Coyd when Janet was the executive director of the Nature Conservancy office in Rhode Island. Part of my considered opinion that we're likely to win is based on the nature of the case that has been put in and the background knowledge and experience and integrity of the EFSB members. Yes?
My question is in regard to that third member that came in many months after this process started. And she missed all the public comment, the emotional, important, and very passionate comments. And I don't know how much that weighs in on the decision, but then again, while through the process, as we saw her sit at the panel, she hardly ever asked a question, even when it pertained to statewide planning, which is supposed to be her forte. I don't know what to read into that.
Well, so to answer your question directly, I wouldn't read anything into that. To get a little bit more technical, Rhode Island law has a well-defined process of how to deal with that situation, because this is not the first time it has happened. When there is a board or a tribunal, such as the EFSB, but others also, and there is a vacancy and then a new member comes on, and there is an old case, there's evidence, and then there's a decision to be made, the requirement is that the newly arriving member has to certify that they have read the entire record of the case. That means the transcript of all of those public meetings that were held in Burrillville Middle School and Burrillville High School. And I will give you an even more extreme example that I've witnessed here in Rhode Island in a case that I was involved in. I happen to be the CLF lawyer who is handling what is now CLF's oldest, longest running lawsuit. It was started in May of 2003. It has been to the Rhode Island Supreme Court 3 times so far. I'm the third lawyer to handle it. And it was before, it's now in Superior Court, but it was before the Coastal Resources Management Council. Well, the case went on for years. There were tens of thousands of pages of exhibits, of documents, of hearings, of transcripts, and there were not one, but I think 5 new members of the Coastal Resources Management Council that ultimately had to vote on this marina application. They voted in January of 2011. And these people, you know, hadn't been on the council for these years and years and years of litigation. They voted, they participated, one by one they said, I certify that I have read the record and participated. So there's a well-defined procedure for what the law does in that circumstance. This is not, doesn't happen all the time, but this is not that unusual. And although you are right that Meredith Brady was not there for the hearings in the high school, I was disappointed that she wasn't there for my opening statement because I thought I did well. Nevertheless, she is very, very, very well familiar with the case. She heard Invenergy's witness, Jason Ringler, on the environmental impacts get totally demolished. She saw the cross-examination of Invenergy's project manager, John Nyland, who couldn't explain lots of untrue things that Invenergy had said. She was there when This was the last day of the hearing. John Nyland, Invenergy's project manager, was on the stand. He was being cross-examined not by me, but by Mike McElroy. And Mike asked him, do you think that Invenergy will get a capacity supply obligation from the ISO in the future? And John said yes. And Mike said, how come? Why do you think that? And Nyland said, well, because our expert, Ryan Hardy, says so. And Chairperson Curran interrupted Nyland and said, what? Hardy has been wrong about everything so far. Why would you have any confidence in what he says? Meredith Brady was there for that. She saw that. The fact that Ms. Brady may have missed my opening statement, I think she's going to know how to vote. Yes, ma'am.
I'm concerned on some of the statements and approvals of some of the people in this EFSB court, because and I would not take a stand or guarantee. I mean, Janet Point alone is someone whose grassroots community has definitely not recommended the reappointment of herself as the director. She has done a disastrous job. She's not reliable. She goes with politics, and she has polluted and contaminated all our frontline people of color, low-income communities. She does not have the environment in her best interest. So it's just like, it's concerning to hear good phrases about Janet Hoyt, because all she does is come into be present in these panels for PR purposes. But you know, she was instrumental in having the LNG plant permitting go through in Providence, and in a very bad way. I mean, she had police details throwing, you know, I couldn't even get into one of the hearings because I had a laptop. I mean, the ridiculous obstacles that the community was placed with under her director and leadership, it has been horrific. And so I have no, I went to her reappointment session. I told her in her face why I was not supporting her reappointment. The No LNG campaign also wrote a statement. Many people in the grassroots community were against it. So I have really no trust in this yet.
So your observation reveals that different folks have different opinions on the same subject. Yes?
My question was on the property that Invenergy has for mitigation. I don't know if you know much about it. It's on East Avenue, and it wasn't that long ago we saw a couple cars in there and we see new survey markers. So it seems like they're like in there. And it seems like it's kind of late in the game to be doing, I don't know, spending time and resources in there. Is that anything we should think about? Or?
So no. Invenergy, because they are moving ahead, because they are likely to appeal if they lose in the EFSB, there are things that they need to do to move their case along. A year ago or so, they were taking some soil samples from the interconnection line where they were going to connect their power plant to the nearest electricity substation. And they tried to portray that as being a big deal. They're going to do surveys on the proposed mitigation parcel. They're going to continue to send 6 lawyers to the EFSB. They're going to try to move the interconnection docket ahead. Even as we speak here today, they are filling out documents for the ISO called the qualification package in order to be permitted to participate in this next forward capacity auction in February of 2020. what they have decided to do for now is to pursue the case. And that means that they continue to spend money on multiple things, including the mitigation package, including the proposed site. They've been taking new surveys at the proposed site, and when we were there a week and a half ago with them, they had new electronic devices that showed where different things might be. What now is important is whether or not the EFSB grants a permit. The fact that Invenergy is doing 12 or 15 or 18 different things in aid of a plant is not a problem. Yes, Rich.
Jerry, in recent developments, it's been reported that the state-of-the-art plant, Invenergy plant in Jessup, Pennsylvania, has violated numerous air quality issues and have, in fact, failed to report some. How likely is it that members of the EFSB have heard any of those reports? And I mean, I know this was all after the final testimony in front of the EFSB, but how likely is it that they might know just, you know, what's going on in Jessup?
So I'll answer the question you asked first, and then I'll go on. I have no idea how likely it is that they would or would not know about the recent events in Jessup. However, I have a pretty high level of confidence that if they do know, they will not allow it to influence their decision because those facts are not in evidence. And their legal obligation is to decide the case on the evidence and on the law. So that is unlikely to have really any effect on the outcome of the case. I won't go into the nice legal question of the degree to which that sort of outside knowledge should or should not influence them. Can they pretend they don't know what they know? Can they be asked to ignore something that they jolly well know? I don't know if they know it. I think that it will not influence the decision. And if you think about it, that's not necessarily a bad thing, because what they know is that the plant isn't needed, the plant would cause unacceptable environmental harm. Under Rhode Island law, with the evidence that's in, the permit has to be denied. We don't need to look to Jessup, Pennsylvania to figure that out. So, yes?
Jerry, I'm very happy that you brought up that subject of a third lady on the panel.
I didn't, because your friend over here did.
Yeah, we don't know anything about her, and we were scared of her because, like people said, she hasn't participated hardly at all. So I'm glad you brought that up and explained that about her. Now, the other subject is that what do you think about Connecticut and Massachusetts, right on our border, with preserved land? Do you think they should have given us a little more help in this here and said, you can't build that plant, that's going to come into our area too. Wallam Lake is half in Mass and half here.
The honest answer is I wish I had thought of that earlier. That's a great idea. Now I'm embarrassed. I wish I had thought of that earlier. I mean, it may not have worked, but there's no downside to trying.
Right. The other thing is, Jerry, is I'm a common sense fellow, right? Everywhere I go, even today, people run into me and they say, oh, that plant's going to get built. And I'm afraid to, I tell them no, but in my heart, I still don't really know. Common sense tells me absolutely not. But people that hasn't followed along just a little bit here or there, they think this plant is going in.
Well, I don't know what to say to that, except the good news is I think we'll have an answer by 5 p.m. on Tuesday, June 25th, and then we will know for sure. And I am not promising you that I'm right, but I do hope that I'm right. Yes, and then we'll come back here.
How could they possibly approve an application when all this evidence, you know, the ISO is, you're not participating in the ISO, the environmental issue? On what grounds can they say, I mean, hypothetically, if they approve this, what would their defense be in backing that?
Actually, that was exactly what I was going to say. Is there, under what circumstances would EFSB agree with Invenergy?
We lawyers who've been litigating against this plan have spent a lot of time making the argument for why this plan needs to be permitted. And you've asked the right guy, because I can make the argument. CLF says that the energy markets now show that the plant isn't needed. And that's not true. And that's true today, but CLF says that energy markets are fluid and dynamic and always changing. And you know, if those environmentalists have their way and we electrify the transportation and the heating sectors, we're going to need more electricity in the future, not less, so we need new power plants. Secondly, this is the most efficient gas-fired power plant on the system, and if built, this plant will back off dirtier, oil-fired and less efficient gas-fired plants, thereby reducing overall carbon emissions. Yes, this is not a good place to build a power plant, and it is true that as early as 1996, the Nature Conservancy identified this land as being uniquely valuable between Maine and Washington, D.C., and in 1999, DEM tried unsuccessfully to buy the land to take it out of development permanently. But, you know, there's no, even CLF's witness said there's no perfect land in Rhode Island or anywhere in the Northeast. You've got to build a power plant somewhere. No plant is going to have zero environmental impacts. And don't forget, since utility restructuring in Rhode Island in 1996, if this plant is built for $1 billion and it never produces one electron for the electricity grid, the cost, the financial risk would be on Invenergy, Invenergy's unsecured borrowers, Invenergy's owners and bondholders, and not on ratepayers. Ratepayers won't suffer. So what's the downside? We can build this wonderful, highly efficient, excellent power plant. That's what the argument would be. It would not completely ignore the arguments against the plan. It would go around them. Sure, there's no need today, but it might be needed in the future. Now, I will say one thing about that middle argument, about how this is the most efficient gas-fired turbine on Earth and will back off less efficient gas and oil units. And I will say that that argument is factually correct as far as it goes. And the reason the argument fails is that the era of fossil fuel power, of carbon-emitting fossil fuel power plants is over. The idea that it is true, it is factually correct, that a more efficient gas plant will back off a less efficient oil plant. It is factually correct. The reason this plant shouldn't be built for environmental reasons is that the time when it is environmentally or morally or ethically or legally acceptable to build another long-lived carbon-emitting fossil fuel power plant is past. One thing we know about natural gas infrastructure is that it is long-lived. The reason that we have so many natural gas methane leaks from gas infrastructure pipes in the old East Coast cities of Boston, Providence, New Haven, Baltimore, New York City, is that all of that natural gas infrastructure went in 1905 and 1910, and it's still there today. Invenergy tells us that this power plant could be online in 50 years. It wouldn't, if it were permitted today, it wouldn't exist until 2023. 50 years, that's 2073. 2073. We can't have fossil fuel power plants in 2073. So although it is technically, factually true that this is an efficient gas-fired plant, the answer is you can't build today a new fossil fuel power plant that will be burning fossil fuels in 2073. You can't do it legally, morally, ethically. It's not okay. But you asked for the decision from the EFSB that permits the plant. I gave you the decision. Yes.
Just then, so how would you? So if EFSB then votes in favor of Invenergy, how would you then move forward to counter them, and what would your argument be against having a top of the line?
Our argument would be what our argument in the Supreme Court would be if it comes to that is we disaggregate, we separate the component parts of the statute. The EFSB cannot legally grant a permit if the plant is not needed, and all the evidence in the case, including from Invenergy's witnesses, shows that the plant is not needed. The plant cannot legally be built if it would cause unacceptable environmental harm. You know, when you have a litigation going, both sides hire experts to say what that side wants. But in this case, DEN, decades before this case was ever conceived of, before Michael Polsky was in the energy business, DEM tried to unsuccessfully to buy this land to protect it because they knew correctly that this was a uniquely valuable piece of land that could be damaged by building a power plant there, looking from Maine to Washington, D.C. So what we would do in a sort of good lawyerly way if we are forced into that position is we disaggregate the sections of the law. We show how the evidence in the case shows that the plant cannot be permitted. It isn't needed. It would cause unacceptable environmental harm. Invenergy's witnesses weren't credible. Credibility is always an issue in the case, in every case, because if you can't believe what a witness says, you can't believe what a witness says. Let me be very, very, very clear. Because I am a smart enough lawyer to know what the arguments on the other side are, doesn't mean that I think that those arguments are right, because I don't. They can make the argument, but the fact is we are right, and I think we will win because the law and the evidence is on our side. That's why I think we will win. Rich.
So I'm sure you'll agree that those people that have been attending the hearings have been quite polite and not caused any disturbances and not gotten thrown out of the EFSB. But on June 25th, the decision comes in our favor, and we give them a big cheer from the audience.
I will stand on what I said, that everybody ought to be paying attention to matters of decorum. And if I am quoted on that, And that statement appears on the front page of the Providence Journal tomorrow. I will not be embarrassed, nor will I be in trouble with my employer. Yes?
I appreciate all of your information. And I don't want to sound like I'm negative, but I am concerned of some environmental justice and environmental statements as factual because frac gas plant is as toxic as an oil plant if you look at from the source to delivery. So, just going to the frac in North Dakota, I mean, you can't even breathe the air. There's a fog, there's a haze. You see all the flares. I mean, in a sunny, beautiful day, you can't see the landscape. It's all hazy. The water, the lake, you can't swim in it because it's all contaminated due to the fracking. The underground life, it's a mass extinction that's happening underground, under the soil. And you have Sandra's stain grabber, and I recommend everybody reading the book Living Downstream, an ecologist's personal investigation of cancer and the environment. It's focused on fracking. She's a biologist and an environmentalist and activist, and also the film Unfractured. It's serious stuff. We should be as concerned as if an oil plant is coming to Rhode Island. And the other thing is that with the LNG plant in Providence, it's not needed either. Even National Grid had on its website, we only need it for 4 to 9 days of the year, and the rest is for export. And yet, it still passes. So what I'm saying is, there are so many political strings and so many political interests here that I would encourage organizing to continue and not stop, because there's no guarantees. I would like to have that positive outlook and I want the positive results, but I don't think that we should rest until we have a final and that we should keep organizing.
So let me just say 2 things briefly in response to that. Taking your last thing first, both CLF as an entity and I personally agree with you, don't merely agree with you, but agree with you emphatically that this is not the end. There is a lot more to do. Second, with regard to the environmental problems of fracked gas, CLF agrees with you, I agree with you, and that's why we put some of that evidence in on this case, because we agree with you on that.
I think we only have time for a few more questions. This gentleman's been super patient.
I apologize for
missing me. So it's hard for me to look at this without, looking at it from a business perspective and my business sense. So there's a direct relationship in my view, just because it's gas related between the LNG facility that's getting built or will be built in Providence and this plant, right? One won't exist without the other. And so if this gets stopped, like say, like you mentioned in June, the end of June, and the LNG facility gets built, you don't think those conversations about this plant are gonna come about? Even if it's another company suggesting it, because they don't compete with each other, the oil companies. It's an industry and they're more like partners. So, it kind of goes related to what Christina was mentioning with the fracking and, so any thoughts on that? Like,
the question of whether another power plant may be proposed for the same location if this one is turned down is a very, very complicated one. And I just want to say one thing about that, while acknowledging that this is not the only thing that you can say about it and that it is complicated. If the permit for this plant is turned down, I think, although the decision will be multiply determined, there will be many factors that contribute to that, the largest single factor will be that the plant is not needed, the plant won't be able to be financed because they won't be able to sell their electricity to the ISO, and that means that other power industry companies that are motivated by a profit motive and want to make money will not have the economic or financial or pecuniary incentive to step in where Invenergy left. The reason why, when I'm at ISO meetings, the owners of all the other big fossil fuel power plants in New England say to me one by one, geez, if this were my company, we would have pulled up stakes and left a long time ago. The reason they say that, these are big energy companies that have profit motive at the heart of what they're doing. They see that there's no economic, financial incentive to building this plant. The plant can't get financed. The plant won't be able to sell its electricity. They wouldn't be interested. So it is a big subject whether someone else will come in there, but I don't think you're going to see that very soon.
Jerry, can't the town buy that land? And what do you call it? Nobody can ever buy it.
Well, the town can only buy the land
after this is done.
No, if somebody will sell it, if the current owner will sell it.
Can't they take it by domain?
Not unless they have a legitimate purpose for it. That is a complicated legal issue, but you can't, in order for anybody to buy anything, land, cars, oats, widgets, you gotta have a seller. And if Spectra doesn't want, the reason why DEM failed in its 1999 effort to buy this land and take it out of development was that the then current owner would not sell it for that purpose. It would not surprise me if the current owner did not want to sell it for purposes of preservation.
But it is going to be rezoned, we were hoping, so that maybe it would be more difficult for the next applicant to come in and propose a policy.
Do you want me to stop or take one more question? What do you say?
How about one more?
That's 3 years. Come on, all 3.
How about these are the last 3?
Sure,
Well, I
let's.
just want to capitalize on the land thing. Didn't Invenergy, when, you know, they were realizing that they were in trouble with the proposal as it was, didn't they buy 2 pieces of land there? And they said, oh, we're going to plant all these trees and everything to sort of mitigate what would happen if they built the plant. So did that happen?
I
Did they
was not
buy it
aware
from
of that, but I'm not saying that it couldn't have happened. But no, I did not know that.
No, it didn't happen.
It didn't.
They have options on 2 properties in the town of Burrillville.
That Spectra owns,
No, these are private parcels of land.
but contiguous?
No,
Contiguous
Okay.
to Blackhawk
Oh,
Hill.
okay, so there was one over here, and then we're going to be here, and then I think we're going to.
Correct.
Yes.
I just wanted to say at the rally last night, it's just to encourage us all that have been in this fight for 4 years to keep continuing and encouraging each other to keep going on. If it is permitted, we have to move on because it has to be stopped. And I also wanted to ask you about the water that was approved by the judge in Situate water. Has that been appealed?
That has not been appealed.
But don't we need to, just in case?
I believe that Burrillville made a decision not to appeal. CLF made a decision not to appeal. The reasons internal, I don't know about Burrillville, we had multiple reasons. One is that we are concentrating, as we have been since the beginning, on stopping this plant at the EFSB.
Okay.
Yes.
Just a quick question. So just to finalize, so if this has to go forward to the Supreme Court, right?
Goes to the state Supreme Court.
The state Supreme Court, is that the decision made at the state Supreme Court would be the last decision made, and that would be, there can't be any more that'd be the end of it, whoever they decide. No.
Yes, and, well, I want to be careful with the answer in order to be strictly accurate. So, if the EFSB grants a permit and we take an appeal to the Supreme Court and the appeal is, or if they deny a permit, EFSB denies a permit, Invenergy takes an appeal, the denial is affirmed, it's upheld at the Supreme Court. Is that the complete end of the case? Yes, in the sense that that case is now over. There's no further court, there's no further appeal, it doesn't go back to the EFSB. But Invenergy cannot be built without a separate permit from the EFSB for the interconnection which Burrillville is fighting. Invenergy cannot be built without a DEM wetlands alteration permit, which is going through DEM now, and my CLF colleague, attorney James Crowley, wave your hand, James. CLF is challenging the wetlands permit in DEM. Please don't ask me questions about the wetlands permit because you'll embarrass me. Invenergy cannot be built without obtaining a capacity supply obligation from the ISO, allowing them to sell the electricity and make money, both because they won't have anybody to sell the electricity to and they won't be able to collateralize loans to build the plant for $1 billion. So, as a legal technical matter, this case will be over after the Supreme Court rules as it will rule. But Invenergy can't automatically be built then because we are fighting Invenergy on multiple other fronts as well, and we will not throw in the towel because that's not what we do. That's a metaphorical towel. Thank you all very much for your patience.
Many of you are experts on this issue, but this gentleman made a great point about Massachusetts and Connecticut. One of the things we're working on at the State House related to climate change is getting tough laws on the books in Rhode Island. Both Massachusetts and Connecticut have tougher climate laws than we do, called the Global Warming Solutions Act. So it's harder to do bad things there. So regardless of how this fight goes, and I hope Jerry's optimism prevails, but we need you with us at the State House passing tougher climate laws here in Rhode Island so communities like yours do not have to go through this. Thanks, everyone.